Well, the state's case saw some witnesses who were inside the house testify, and their versions that two intruders entered the house. And what exactly were their roles? Accused number 3, Mthobisi Mncube, carrying a gun, and accused number 2, Bongani Ntanzi, followed him inside. Well, the state believes accused number 1, Muzi Sibiya, and accused number 4, Mthokoziseni Mapisa, were outside, while accused number 5, Fisobuhle Ntuli, was the man with the getaway car. This, a view even held by the lead investigator, Brigadier Bongani Kininda. But exactly how were all the 5 men linked to the offence? The High Court in Pretoria heard that, amongst others, it was accused number 2, Bongani Ntanzi's confession that blew the lid and changed the course of police's investigations.
When I was walking away, my lord, I just don't remember which of the 2 members called me to say he wants to speak to me. This is now accused 2. My lord, when I returned, what he then said amounted to what led to the arrangement of the confession that was taken by Lieutenant Colonel Rapado. And he was cautioned, my lord, in terms of his constitutional rights. I've dealt with this thing. I just don't want to burden the record by repeating the same thing, my lord. But I did caution him in terms of his constitutional rights when he made a confession, because in essence, he admitted that he was involved. He implicated accused number 1, 3, 4, and 5. Further mentioning my recollection, my lord, Mrs. Kelly Kumalo as the trigger point or the person who hired them to kill the deceased.
Well, Kininda told the court that he had requested that Kumalo be charged, but a decision was taken that a further probe be conducted. And while DNA results had excluded all the accused inside the house as well as on the hat, but the state believes that some traces of their DNA markers that were found were significant to place some of the accused there. Well, fast forward, after multiple delays, drama, postponements, the state finally wrapped up its case, believing it led strong and credible evidence.
The state had been indicating in the course of the leading of its evidence that it would not be calling certain witnesses. Those witnesses will be made available to the defense. Now, I want to, actually this is just a re-emphasis that from this point onward, in other words, henceforth, the defense is now in liberty to consult with whoever's name appears in the list of the state witnesses if circumstances were to arise. I just want to confirm if my understanding in that regard is correct, my lord.
As a court, my lord, the law is very clear that any witnesses who is not called by the state is at the disposal of the defense, and that will obtain here. We make all witnesses that haven't been called we make them available to the disposal of the defense.
The defense indicated it will apply to have the charges dropped against the accused.
Got instructions from our clients that we need to bring an application in terms of section 174. Which instructions we communicated to the financer of their defense, who is the Legal Aid South Africa. And Legal Aid South Africa then requested us to request an indulgence from the court to have the matter stood down for a week or 2, whilst they would be busy working on their CMC. I don't know what that stands for, but I think it's a head committee there on the modalities regarding the financing of the application in terms of section 174, my lord.
But what are the prospects?
The defense is saying that they did not prove a case beyond a reasonable doubt, and the defense has indicated that they will be bringing an application for the discharge of their clients in terms of section 174 of the Criminal Procedure Act. Now, what Section 174 clearly states is that it is a safeguard in order to prevent accused persons from being convicted if a case is not proven against them beyond a reasonable doubt, and that the only inference that can be drawn from them having to testify and from presenting a case is that they will in fact incriminate themselves even though a case has not been proven against them by the state. So I think we can expect that Section 174 application by the defence when the matter resumes, and then it is up to the judge to decide whether to grant the Section 174 or for the judge to say, well, I don't agree with this application. In fact, I do think that there is evidence on the record and that has been proven by the state that deserves to be answered to. And accordingly, I call upon the defence to present their case. If the judge makes that ruling, then the defence case will entail the calling of witnesses, the possible calling of the accused, and other possible eyewitnesses. And as we heard in the snippet earlier, any witness that the state did not call during the proceedings will now be made available to the defence to also call in an attempt to show that their clients are in fact innocent of these charges. So, it's difficult to say now yet whether the case has been proven against them beyond a reasonable doubt, because I do think that there is evidence that's been placed on the record that needs to be answered to.
Crisalda Lewis, SABC News in Johannesburg.